One of the cases we're going to be talking about today is a pretty new case, just with a couple months old, from the New Jersey Supreme Court called I think it's State versus Ventura is the name of it. And Ventura is a case dealing with a bail forfeiture for people who actually left the state as fugitives. And while the bounty hunters were trying to find them, they got arrested by other authorities that were held on immigration detainers. And then while they were trying to process them to get them extradited back into New Jersey, they were deported out of the country and went to other countries. So they were really beyond the jurisdiction of the United States to do anything with it. That's the substantive issue we're going to be dealing with. But in the case, the New Jersey Supreme Court cites, and I think this might be the first time they've ever cited it, is the very famous Taylor versus Tainter case from 1872 from the United States Supreme Court. It's one of my favorite cases. So I wanted to kind of talk about that as a starting point in the development of the law on bail forfeitures and remissions. But I have to tell you that Tainter versus Taylor, although it's an 1872 case, it doesn't really create any new law in the sense that all it does is repeat what the common law had been, not only in the United States since colonial times, but going back into England into time immemorial. Ever since they've had sheriffs and bail, they've had the common law dealing with bail forfeitures and remissions. And Taylor versus Tainter does nothing more than restate that. It's a really kind of a routine case. The facts of it involved a guy who was in Connecticut and was the subject of what would today be the functional equivalent of an indictment for some type of criminal offense. Bail was set in the amount of $8,000, which I have to think in 1866 was when the offense occurred. That was a lot of money. But he was able to persuade some type of bonding company to bond him out, so he was released on bond. Then left Connecticut pending his trial to go back to his home in New York. Now, while he was in New York, people who would be the functional equivalent of the Marshal's task force came and grabbed him and extradited him to Maine, where he had an active criminal matter as well. He went to trial in Maine, got convicted, and was sentenced to 15 years in Maine. Despite the best efforts of the bounty hunters, I guess, of the era, they couldn't get him released from Maine. They couldn't get him back to resolve his case in Connecticut. And that resulted in a forfeiture of the $8,000 of bail that he had posted. So this is the case that kind of went to the United States Supreme Court. This decision was written by Justice Swain. Justice Swain had been a Lincoln appointee. He was appointed to the Supreme Court in 1862 by Abraham Lincoln and was still hanging around in 1872 when it came time to write this opinion. As I said before, the opinion is really kind of a straightforward contracts case more than anything else dealing with this recognizance. But what makes the case interesting is that, and I guess you could just call this dictum more than anything else, he has a passage in the case which has nothing to do with the resolution of the issues, which is really kind of spurred on the bail bond industry, and I want to read it to you, okay? So this is Justice Swain writing in this opinion. When bail is given, the principal is regarded as delivered to the custody of his sureties. Their dominion is a continuance of the original imprisonment. This is all just the restatement of the common law. Whenever they choose to do so, they may seize him and deliver him up to their discharge. And if that cannot be done at once, they may imprison him until it can be done. They may exercise their rights in person or by agent. They may pursue him into another state, may arrest him on the Sabbath, yikes, and if necessary, may break into his house for that purpose, double yikes. The seizure is not made by virtue of new process. None is needed. It is likened to a rearrest by the sheriff of an escaping prisoner. In a case called Modern, it is said, the bail have their principal on a string and may pull the string whenever they please and render him in their discharge. The rights of bail in civil and criminal cases are the same. They may doubtless permit him to go beyond the limits of the state within which he is to answer, but it is unwise and imprudent to do so. And if any evil ensue, they must spare the consequences and cannot cast them upon the obligee. So I guess, again, this is nothing more than a restatement of the common law, and I guess to a certain extent this is still the common law in New Jersey now. I don't know if there's been a whole lot of statutory law which has changed any of this, but when you see these, Dog the Bounty Hunter shows with like breaking down doors and stuff, they're relying upon this passage in Taylor versus Tainter. The mention of it by the New Jersey Supreme Court in the Ventura case is related to the defense of impossibility. In other words, you're asking for exoneration of the bond because it's impossible for you to comply with the terms and conditions of it because of act of God or because some type of act of law legitimately made it impossible. And in this particular case, the ruling was that it was not impossible, that they really had been negligent in terms of supervising this guy. So With that as a background, let's talk about some of the case law and court rules that control the activity of bail, forfeitures, and remissions. Let's start off just kind of with a couple foundational issues in terms of the right to bail. This court rule, which is 326.1, applies to the Superior Court, is nothing more than a restatement of the exact words that are in the New Jersey State Constitution, okay? So all persons except those charged with crimes of death, when the prosecutor presents proof that there is a likelihood of conviction, that's not the exact words that they have in the Constitution, but it's similar, shall be bailable for convictions on such terms as the judgment of the court will ensure their presence in court when required, okay? So this is essentially a constitutional requirement. It doesn't apply in the federal system, because in the federal system, although if you get bail at all, the bail has to be a reasonable amount, but you don't have a constitutional right to bail federally. There is no recognized, Eighth Amendment right to bail. But here in New Jersey, everybody has a right to bail. And I guess now, since the death penalty has been abolished, everybody has a right to bail. The bail factors here are seriousness of the crime, criminal record, reputation, length of residence in the community, family ties, employment status, record of employment, identity of responsible members who will vouch for the reliability. Those usually the people who are going to post the bail. Any other factors, including mode of life and community, bearing the risk of failure to appear, particularly the general policy against unnecessary sureties and detentions, okay? So that's kind of the public policy in our state in terms of unnecessary sureties and detention. At discretion, the court may order the release of the person on his own recognizance. Now, this is very important here. Court may impose conditions appropriate to defendant's release, including conditions necessary to protect persons in the community. Vitally important rule for sureties and their agents to know about, because when the bond is done, you kind of adopt all these conditions of bail, and there's a violation of the condition of bail. Apart from not showing up in court, that can lead to a forfeiture. Or, alternatively, if the court, as we'll see, if the court puts a condition on bail after the fact which materially increases the risk to the surety, that again would give the surety an opportunity to have the bond exonerated and have him go find his bail someplace else, or increase and get more premium out of the guy, okay? So you should be citing this rule as kind of a basic principle when you go forward. Now, in the municipal court context, it's a little bit different, because they don't have the same bail factors that you're supposed to consider when you're deciding to set bail. The equivalent municipal court rule is 7:4-1, and just says that you have the right to bail before conviction on such terms as the judgment of the court will ensure the defendant's presence required, having regard for the defendant's background, residence, employment, family status, in particular, the general policy. So it's kind of cut and pasted. In its discretion, the court may order release on recognizance and may impose terms and conditions appropriate to release. Same type of principles that you get in Rule 3:26.